The next matter to come before us this morning is Brunswick Hills Township Board of Trustees versus G&K Construction, Inc. et al. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you are the appellant and wish to reserve that time, please let me know. I'm keeping the clock this morning. We've read the briefs and we are ready to proceed when you are.
May it please the court, opposing counsel, my name is Attorney Joseph Salzgeber and I represent defendant appellant G&K Construction and their owners, Mr. and Mrs. Kaminsky, in this matter. Although the brief is rather lengthy, as was the hearing, this matter is relatively straightforward in terms of argument. It's our argument that Brunswick Hills Township was equitably estopped from asserting that the use by my clients was improper, where that non-conforming use had been permitted going back to the beginning of the township in 1960. As the record indicates, Buckeye Pipeline owned a pumping station at that location on Boston Road in Brunswick Hills Township, predating the establishment of the township's zoning records. It was industrial non-manufacturing use at that time. Buckeye ceased their operations in 1965, their active operations, but they still owned the property until 1979. There's pipes traversing the underground at that property. They sold it in 1979 to an Andrew Planet who had a construction business. Mr. Planet subsequently sold that property in 1994 to my clients, G&K Construction. Now my clients, Mr. and Mrs. Kaminsky, who are the principals of G&K Construction, they sold their home in the Brunswick area in order to be able to buy this property, to take a risk and locate their own excavating and construction business at that location. And before they did so, before they sold their home and purchased this property, they did their due diligence and checked with the county tax maps. They checked with Brunswick Hills Township's zoning inspector, Mike Ruby, longtime zoning inspector, and the maps at Brunswick Hills Township. And what they learned was that that property, according at least to the records, was zoned industrial non-manufacturing, or at the very least that was a permitted use at that location. There was testimony from both Mr. and Mrs. Kaminsky that they did so. There was testimony from Beth Mika of the Medina County Tax Map Department, which prepared the zoning maps based upon the information provided to them by Brunswick Hills Township, that this property was zoned industrial non-manufacturing. Otherwise, my clients would not have purchased this property in 1994, risking their home to do so.
The township, though, is saying that you've waived this equitable estoppel argument.
Well, it was raised, Your Honor, below.
How was it raised?
It was raised, I believe, in the defense, in the answer, and it was also alluded to by Attorney Bruce Hall throughout the record.
You concerned me when you used the term alluded.
Well, he raised it, and it was, I don't think he used the actual term equitable estoppel, is what I'm saying when he alluded to it. But the argument is there throughout.
What did he raise in the answer?
He raised that he raised an estoppel argument that.
Did he use the word estoppel?
I believe so, yes.
Okay, because we'll check obviously in the answer, but I'm just wondering. Are there any counterclaims? I'm assuming no, based on the briefs.
No, there were no counterclaims. This was an action by the Brunswick Hills Township.
And then the other question is, they also say waived it by not filing objections to the magistrate's decision.
Well, I think they would have been happy with the magistrate's decision. It was a subsequent decision by the judge who overruled the magistrate and went much further.
Well, I'm thinking about that too, because
I think they could have lived with, you can't put your vehicles within 5 feet of the property line. You can't have rubbish on the property.
Right.
But they could still operate their business. The magistrate's decision did not effectively prevent them from operating their business at this property.
But nonetheless, they still lost on some of the claims.
Yes. Yeah, so we're really our only issue is with the judge going the next step and saying, well, the non-conforming use was abandoned, so you're out of luck. And that all the use from 79 forward was unlawful. And even though, Brunswick Hills Township, their own records indicated this was permitted, my clients are sort of left holding the bag here. They did their due diligence, they checked the records, they spoke with Mike Ruby, who is the zoning inspector. They were told by him that you can go ahead and put your construction and excavating business on this property because that's a permitted use.
In the state of Ohio, do you have any case law to support that we allow equitable estoppel as it relates to a public entity like Brunswick Hills Township?
There is a case, Franklin Township versus Meadows, in which the court noted that equitable estoppel prevents relief when one party introduces another that believes certain facts exist and the other party then changes their position in reasonable reliance thereon. I believe that is a zoning case. It's 1998, 130 Ohio Ave 3rd, 704.
And is that in your brief?
Yes, that's on. The case law is admittedly sparse, but it's cited on page 17 of the brief. In this case, the four elements of equitable estoppel are in fact present, where Brunswick Hills, the Brunswick Hills Township and its Board of Trustees, they were admittedly incorrect, but they're the ones who are supposed to know these things. They're the government entity that's responsible for knowing how the property is zoned within its own jurisdiction. My clients did their due diligence when they checked on the property before purchasing it. The representation that the property was in fact zoned industrial, non-manufacturing, induced them to go ahead with selling their own house to get the funds to buy this property. And now they're severely prejudiced if they can't use the property for the business that they put there and for which they purchased the property over 20 years ago. Based on the arguments set forth in the brief and the case law set forth there, we would ask that this court reverse the judgment of the trial court below and remand with instructions to permit this use of the property. Thank you.
Okay, please the court. I am Tom Karras. I am with the Medina County Prosecutor's Office. As an assistant prosecutor, I'm appearing on behalf of the appellee, the Brunswick Hills Township Board of Trustees. The one assignment of error is that the trial court below did not consider the doctrine of equitable estoppel in its ruling. Unfortunately, the appellant's appeal fails on three fronts. First of all, most importantly, the doctrine of equitable estoppel is not available as a defense against the actions of a political subdivision, which Brunswick Hills Township certainly is. In the case of Hortman versus the City of Miamisburg, it's a Supreme Court case. It clearly says that it's inapplicable against a political subdivision.
What was the date on that case?
I believe it was, let's see.
I mean, I can look it up. But the reason I'm asking is because I pulled up Franklin Township versus Meadows as we were all talking about it, or at least while at the Balance Council was talking about it. And we don't really need to get into the issue in Franklin Township versus Meadows. But we do talk as if this court, speaks as if equitable estoppel is valid.
Let's see. I'm trying to see. I do have.
So I'm just wondering about that.
Okay. The case of Portman versus City of Miamisburg was 2006. And this is an attack against the zoning of the township, and that was clearly in Wilbur versus Rulio was said to be a government function. As long as what Hortman says is that as long as this is a governmental function, that estoppel does not apply. It's not in State versus Farley. The political subdivision is not bound by the statements of the employees as to what is and what is not a permitted use. And in Powell versus Springsteen, a mistake does not provide a basis for application of estoppel. All these were issues of address the issue of estoppel in their defense. On another front, the appellants say that they did assert the affirmative defense of equitable estoppel at the trial level, and what's clear is that in their answer they did not assert any affirmative defenses. They did not seek at any time during the proceedings to amend their answer to conform to the evidence, but therefore under Civil Rule 8 they're precluded from appealing the grounds of equitable estoppel because they waived that affirmative defense. And thirdly, their appeal fails because under 53, and I think Judge Carr, I think you alluded to this, was that there was an objection. There was a magistrate's decision which was not objected to by the defendant or the appellant, and though they had ample opportunity to do so, as the appellee actually objected to the decision of the magistrate, and then that would afford.
If they were in agreement with what the magistrate decided, why would they file an objection to it?
Well, once the appellee has filed the objection, and they see the ramifications of that, the rule allows them the opportunity of 10 more days to file a reply objection, or to file another objection if they so see. So they didn't take advantage of that in either instance. They didn't file an original objection, and they didn't file an objection after they saw the appellee's objection. Also, in regards to the objection, the court had requested the parties prepare findings of fact, their own findings of fact and conclusions of law, and the appellants never took advantage of that and didn't participate in creating that. So, for those three reasons, first of all, that equitable estoppel does not apply to political subdivisions. Second of all, that they didn't take advantage of under Civil Rule 53. They didn't take advantage of raising their own objections, and therefore their ability to raise it now is they waive that ability to raise it now. And third, Civil Rule 8, which they never asserted. They never at any time, though they had ample opportunity, they never asserted the defense of equitable estoppel. And for those reasons, their appeal must fail.
Thank you.
Just briefly in response to opposing counsel's argument, I would note that the equitable estoppel argument is made on the record at pages 5, I believe it's 507 to 23. That's cited on page 3 of our brief. And I would just reiterate, as stated before, that the defendants could live with the magistrate's decision because the magistrate's decision permitted them to continue operations. It affected their ability to lease to others, as had been their practice, to lease portions of the property to other businesses, but it did not affect their own operations. So they could live with that. That's why they did not go ahead and appeal that decision. When the Brunswick Hills Township Board of Trustees appealed, then they got an adverse decision, which was appealed to this court. Just citing the magistrate's decision, the 1983 Brunswick Hills Township zoning district map on file with the county tax map department, it's filed by the township, showed the subject property was zoned industrial light manufacturing. That's 1983, 11 years before my clients acquired the property. The Brunswick Hills Township zoning resolution itself is a zoning map which shows the locations of different zoning districts and also maintains a land use map which showed that the property was used as industrial non-manufacturing. The Brunswick Hills Township Board of Zoning Appeals referred to that property as being industrial non-manufacturing in its use. So you have all of these official records, official pronouncements by Brunswick Hills Township stating that this property is either zoned or may be used for industrial non-manufacturing purposes. And then they're trying to, pull the rug out from under my clients some 20 years later after they purchased the property. We would ask that this court reverse and remand with instructions that these be permitted. Thank you.
Thank you both gentlemen for your presentations this morning. The court will take the matter under advisement and issue a written decision, which will be sent to both sides as well as posted on our website and the Ohio Supreme Court website.